A very good afternoon to you on this Tuesday, the 7th of May, 2024. Today, we are continuing our series on the Macedonian question, and in particular, the PRESPA agreement as cultural genocide of the Macedonian national identity towards the termination of an illegal treaty by Professor Dr. Igor JANNEV. We have already covered 6 chapters comprehensively, and today we are going to be looking at Appendix 1 of that publication. Appendix 1 is titled Final Agreement for the Settlement of the Differences as described in the United Nations Security Council Resolution 817 of 1993 and 845 of 1993, the termination of the Interim Accord of 1995, and the establishment of a strategic partnership between the parties. Preamble. The first party, the Hellenic Republic, the first party, and the second party, which was admitted to the United Nations in accordance with the United Nations General Assembly Resolution 47/225 of the 8th of April 1993, the second party, jointly referred to as the parties. Recalling the principles and purposes of the Charter of the United Nations, the Helsinki Final Act of 1975, the relevant acts of the Organization for Security and Cooperation in Europe, and the values and principles of the Council of Europe. Guided by the spirit and principles of democracy, respect for human rights and fundamental freedoms and dignity. Abiding by the provisions of the Charter of the United Nations, and in particular, those referring to the obligation of the states to refrain in any international relations from the threat or use of force against the territorial integrity or political independence of any state. Emphasizing their full commitment to the principles of the inviolability of frontiers and the territorial integrity of states incorporated in the Helsinki Final Act of 1975. Reaffirming the existing frontier between them as an enduring international border, in full accord on the need to strengthen peace, stability, security, and further promote cooperation in Southeastern Europe. Desiring to strengthen an atmosphere of trust and good neighborly relations in the region, and to put to rest permanently any hostile attitudes that may persist, and agreeing on the need to refrain from irredentism and revisionism in any form. Recalling their obligation, in accordance with the Charter of the United Nations and the international law, not to interfere on any pretext or in any form in the internal affairs and jurisdiction of the other. Underscoring also the importance of the development of friendly relations among states and of resolving disputes by peaceful means in accordance with the Charter of the United Nations. Resolving the differences pursuant to Security Council Resolutions 817 of the 7th of April 1993 and 845 of the 18th of June 1993, as well as Article 5 of the Interim Accord of the 13th of September 1995 in a dignified and sustainable manner, having in mind the importance of the issue and the sensitivities of each party. Taking into account the General Assembly Resolution 47/225 of the 8th of April 1993, taking into consideration the Interim Accord, the Memorandum of 13th of October 1995 on practical measures related to the Interim Accord, the Memorandum on the Mutual Establishment of Liaison Offices in Skopje and Athens of the 20th of October 1995, as well as the process of confidence-building measures, underlying their strong will for mutual friendship, good neighborliness, and cooperative partnership. Committing to strengthen, widen, and deepen their bilateral relations, and to lay firm foundations for the entrenchment and respect of good neighborly relations, and for the development of their comprehensive bilateral cooperation. seeking to reinforce and broaden their bilateral cooperation and to upgrade it to the level of a strategic partnership in the sectors of agriculture, civil protection, defense, economy, energy, environment, industry, infrastructure investments, political relations, tourism, trade, trans-border cooperation, and transport, capitalizing also on the existing CBMs. The two parties have agreed as follows. We're going to take a short break here and then continue in just a moment. The two parties, that is the Hellenic Republic and the Republic of Macedonia, have agreed as follows. Settlement of the difference on the name, the pending issues related to it, and entrenchment of good neighborly relations. Article 1. Number 1. This agreement is final and upon its entry into force terminates the interim accord between the parties signed in New York on the 13th of September 1995. 2. The parties recognize as binding the outcome of the negotiations that have taken place under the auspices of the United Nations, to which both parties have been committed pursuant to the United Nations Security Council resolutions 817 and 845, both of them of 1993, as well as the interim accord of 1995. 3. Pursuant to those negotiations, the following have been mutually accepted and agreed. A. The official name of the second party shall be the Republic of North Macedonia, which shall be the constitutional name of the second party and shall be used erga omnes as provided for in this agreement. This short name of the second party shall be North Macedonia. B. The nationality of the second party shall be Macedonian / citizen of the Republic of North Macedonia, as it will be registered in all travel documents. C. The official language of the second party shall be the Macedonian language, as recognized by the Third UN Conference on the Standardization of Geographical Names, held in Athens in 1977 and described in Article 7, paragraph 3 and paragraph 4 of this agreement. D. The terms Macedonia and Macedonian have the meaning given under Article 7 of this agreement. E. The country codes for license plates of the second party shall be NM or NMK. For all other purposes, country codes remain MK and MKD as officially assigned by the International Organization for Standardization. F. The adjectival reference to the state, its official organs, and other public entities shall be in line with the official name of the second party or its short name, that is, of the Republic of North Macedonia or of North Macedonia. Other adjectival usages, including those referring to private entities and actors that are not related to the state and public entities, are not established by law and do not enjoy financial support from the state for activities abroad, may be in line with Article 7, paragraph 3 and paragraph 4. The adjectival usage for activities may be in line with Article 7, paragraph 3 and paragraph 4. This is without prejudice to the process established under Article 1, paragraph 3H, and compound names of cities that exist at the date of the signature of this agreement. G. The second party shall adopt the Republic of North Macedonia as its official name, and the terminology is referred to in Article 1, paragraph 3, through its internal procedure that is both binding and irrevocable, entailing the amendment of the Constitution as agreed in this agreement. H. In relation to the above-mentioned name and terminologies in commercial names, trademarks, and brand names, the parties agreed to support and encourage their business communities to institutionalize a sincere, structured, and in good faith dialogue in the context of which will seek and reach mutually accepted solutions on the issues deriving from the commercial names, the trademarks, the brand names, and all relevant matters at bilateral and international level. For the implementation of the above-mentioned provisions, an international group of experts will be established consisting of representatives of the two states in the context of the European Union, with the appropriate contribution of the United Nations and the ISO. This group of experts shall be established within 2019 and conclude its work within 3 years. Nothing in Article 1, paragraph 3H shall affect present commercial usage until mutual agreement is reached as provided in this subsection. 4. Upon signing this agreement, the parties shall take the following steps. We are looking for the next page. A, the second party shall, without delay, submit the agreement to its parliament for ratification. B, following ratification of this agreement by the parliament of the second party shall notify the first party that its parliament has ratified the agreement. C, the second party, if it decides so, will hold a referendum. D, the second party shall commence the process of constitutional amendments as provided for in this agreement. E, the second party shall conclude in toto the constitutional amendments by the end of 2018. F, upon notification by the second party of the completion of the above-mentioned constitutional amendments and of all its internal legal procedures for the entry into force of this agreement, the first party shall promptly ratify this agreement. 5. Upon entry into force of this agreement, the parties shall use the name and terminologies of Article 1, paragraph 3 in all relevant international, multilateral, and regional organizations, institutions, and fora, including all meetings and correspondence, and in all their bilateral relations with all member states of the United Nations. 6. In particular, immediately upon entry into force of this agreement, the second party shall notify all, this is A, notify all international, multilateral, and regional organizations, institutions, and fora of which it is a member of the entry into force of this agreement, and request that all those organizations, institutions, and fora thereafter shall adopt and use the name and terminology referred to in Article 1, paragraph 3 of this agreement for all usages and purposes. Both parties shall also refer to the second party in accordance with Article 1, paragraph 3 in all communications to, with, and in those organizations, institutions, and fora. B, notify all member states of the United Nations of the entry into force of this agreement and shall request them to adopt and use the name and terminologies referred to in Article 1, paragraph 3 of this agreement for all usages and purposes, including in all their bilateral relations and communications. Now, there are many other points. However, we're going to have a short break here and now and then continue. Resuming, number 7, upon entry into force of this agreement and subject to provisions under Articles 1, paragraph 9 and paragraph 10, the terms Macedonia, Republic of Macedonia, FYR of Macedonia, FYR Macedonia, in a translated or untranslated form, as well as the provisional name, the former Yugoslav Republic of Macedonia, and the acronym FYROM shall cease to be used to refer to the second party in any official context. 8. Upon entry into force of this agreement and taking into account its Article 1, paragraph 9 and paragraph 10, the parties shall use the name and terminologies of Article 1, paragraph 3 for all usages and all purposes erga omnes, that is, domestically in all their bilateral relations and in all regional and international organizations and institutions. 9. Upon entry into force of this agreement, the second party shall promptly, in accordance with sound administrative practice, take all necessary measures so as the country's competent authorities henceforth use internally the name and terminologies of Article 1, paragraph 3 of this agreement in all new official documentation, correspondence, and relevant materials. 10. As regards the validity of already existing documents and materials issued by the authorities of the second party, the parties agree that there shall be 2 transitional periods, one technical and the other political. A, the technical. Transitional period shall relate to all official documents and materials of the public administration of the second party for international usage and to those for internal usage that may be used externally. These documents and materials shall be renewed in accordance with the name and terminologies as referred to in Article 1, Paragraph 3 of this agreement within 5 years from the entry into force of this agreement at the latest. B, the political transitional period shall relate to all documents and materials exclusively for internal usage in the second party. The issuance of the documents and materials falling under this category in accordance with Article 1, Paragraph 3 shall commence at the opening of each European Union negotiation chapter in the relevant field and shall be finalized within 5 years thereof. Procedures for the number 11. Procedures for the prompt amendment of the Constitution of the second party in order to fully implement the provisions of this agreement shall commence upon ratification of this agreement by its parliament or following a referendum if the second party decides to hold one. 12, the name and terminologies as referred to in Article 1 of this agreement shall be incorporated in the constitution of the second party. This change shall take place in block with one amendment. Pursuant to this amendment, the name and terminologies will change accordingly in all articles of the Constitution. Furthermore, the second party shall proceed to the appropriate amendments of its preamble, Article 3 and Article 49 during the procedure of the revision of the Constitution. 13, in the event of mistakes, errors, omissions, in the proper reference of the name and terminologies referred to in Article 1, Paragraph 3 of this agreement, in the context of international, multilateral, and regional organizations, institutions, correspondence, meetings, and fora, as well as in all bilateral relations of the second party with third states and entities, either of the parties may request the immediate ratification, rectification, I beg your pardon, rectification and the avoidance of similar mistakes in the future. So that was Article 1 to which both parties have agreed. Now there are many more articles, so we will continue shortly with the second article. Article 2. 1. The first party agrees not to object to the application by or the membership of the second party under the name and terminologies of Article 1, Paragraph 3 of this agreement in international, multilateral, and regional organizations and institutions of which the first party is a member. 2. The second party shall seek admission to international, multilateral, and regional organizations and institutions under the name and terminologies of Article 1, Paragraph 3 of this agreement. 3. Upon entry into force of this agreement pursuant to its Article 1, the first party shall ratify any of the second party's accession agreement to international organizations of which the first party is a member. 4. In particular, with respect to the second party, European Union and North Atlantic Treaty Organization, that is NATO for short, integration processes, the following shall apply. A. The second party shall seek admission to NATO and the EU under the name and terminologies of Article 1 of this agreement. Accession to NATO and the EU will be under the same name and terminologies. B. Upon receiving the notice of this ratification of this agreement by the Parliament of the second party, the first party shall promptly, 1, notify the President of the Council of the EU that supports the opening of the EU accession negotiations of the second party under the name and terminologies of the Article 1 of this agreement. 2, notify the Secretary General of NATO, that it supports the extension of an access on invitation by NATO to the second party. Such support of the first party is conditional, first, to an outcome of referendum, if the second party decides to hold one, consistent with this agreement, and second, to the completion of the constitutional amendments provided for in this agreement. Upon receipt of notification by the second party concerning the completion of all its internal legal procedures for the entry into force of this agreement, including a possible national referendum with an outcome consistent with this agreement, and upon conclusion of the amendments of the constitution of the second party, the first party shall ratify the second party's NATO accession protocol. This ratification procedure should be concluded together with the ratification procedure of this agreement. That was Article 2. Article 3. 1. The parties hereby confirm their common existing frontier as an enduring and inviolable international border. Neither party shall assert or support any claims to any part of the territory of the other party or claims for a change to their common existing frontier. In addition, neither party shall support any such claims that may be raised by any third party. 2. Each party commits to respect the sovereignty, the territorial integrity, and the political independence of the other party. Neither party shall support any actions of any third party directed against the sovereignty, the territorial integrity, or the political independence of the other party. 3. The parties shall refrain, in accordance with the purposes and principles of the Charter of the United Nations, from the threat or use of force, including the threat or use of force intended to violate their common existing frontier. 4. The parties commit not to undertake, instigate, support, and or tolerate any actions or activities of a non-friendly character directed against the other party. Neither party shall allow its territory to be used against the other party by any third party, any third country, organization, group, or individual carrying out or attempting to carry out subversive secessionist actions or activities which threaten in any manner the peace, stability, or security of the other party. Each party shall communicate without delay to the other party any information in its possession regarding any such actions or intentions. Article 4. 1. Each party hereby commits and solemnly declares that nothing in its constitution, as it is in force or will be amended in the future, can or should be interpreted as constituting or will ever constitute the basis for any claim to any area that is not included in its existing international borders. 2. Each party undertakes not to make or to authorize any irredentist statements and shall not endorse any such statements by those who purport to act on behalf of or in the interest of the party. 3. Each party hereby commits and solemnly declares that nothing in its constitution, as it is in force or will be amended in the future, can or should be interpreted as constituting or will ever constitute the basis for interference with the internal affairs of the other party in any form and for any reason, including for the protection of the status and rights of any persons that are not its citizens. Article 5. In the conduct of their affairs, the parties shall be guided by the spirit and principles of democracy, fundamental freedoms, respect for human rights and dignity, and the rule of law, in accordance with the Charter of the United Nations, the Universal Declaration of Human Rights, the European Convention for the Protection of Human Rights and Fundamental Freedoms, to the International Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Rights of the Child, the Helsinki Final Act, the document of the Copenhagen meeting of the Conference on the Human Dimensions of the Conference on Security and Cooperation in Europe, and the Charter of Paris for New Europe, and other international agreements and instruments to which both parties are party. 2. No provision of any of the instruments referred to in paragraph 1 above shall be interpreted to give any right to either party to take any action contrary to the aims and principles of the Charter of the United Nations or the Helsinki Final Act, including the principle of the territorial integrity of states. 1. United Nations, the official records of the General Assembly, third session, part P71. 2. United Nations Treaty Series, volume 213, page 221. 31. BID, volume 660 P195. 41 BID, volume 1577, number 1-27531. So I've shared with you all the 5 articles. There are more articles, but we will continue them in a separate recording. You've been listening to In Focus with Silvana Pavlovska, broadcasting from Melbourne, Australia, an independent journalist. I'm looking forward to seeing you very soon. Thank you.